Okay, and it is ready to go. So I am going to turn it over to the judges now. Good luck, everyone.
Thank you, Dr. Cosgrove. Hi, I'm Karen Milton. Good afternoon from New York. And I am the Chief of Staff right now to the Inspector General for the MTA. And the MTA is the Metropolitan Transportation Authority. We oversee the subways and buses of New York City, bridges and tunnels, and of course, the commuter rails in the greater New York metropolitan area. Prior to that, I worked for the federal judiciary for a number of years as the circuit executive in the Second Circuit. Those are the 13 federal courts in the states of New York, Vermont, and Connecticut. And believe it or not, I dealt with habeas corpus in my federal life a lot. So I'm really looking forward to today's conversation from all of you. I'm now going to ask my fellow judges to introduce themselves. After they finish, we're going to ask you to introduce yourselves and also to introduce your team that you have who is here to lend moral support. So Charlie?
Hello, my name is Charlie Hinderleiter. I'm the Director of Government Affairs for St. Louis Realtors in St. Louis, Missouri. I'm a former political science professor, as well as a former participant in the We the People program. So at a national finals that had many fewer numbers than the 34th, I was sitting on that side of the proverbial table. So I'm really excited for our conversation today.
Good morning. Congratulations. Day 2 of the Nationals. You're early in the day. Excited to hear what you have to say. I'm an attorney that practices law here in the state of Nevada. And if you don't change your ways, you're going to end up being like me, and people are going to pay you to talk just like you're going to do today. That was supposed to be a joke, trying to lighten it up. You're excited, have fun, enjoy yourself, enjoy this opportunity. Thank you.
Hi, please introduce yourselves to the judges and introduce your team, your support team.
Good morning, judges. We are Unit 1, and we will be discussing the philosophical and historical foundations of the American political system. We would like to thank you all for being here this morning. We would also like to thank our coaches, Marcus Wood and Debbie Menashe, our student mentor, London, and our teacher, Sadie Adams. My name is Erskine.
My name is Estelle.
My name is Max.
My name is Lila.
And my name is Emily. Thank you. We are now ready for your question.
Great, and we are ready to give it to you. So, Unit 1, question 2, let's do it. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in these United States? And under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? Please begin.
A writ of habeas corpus demands that a prisoner be brought before the court for release unless the custodian can show lawful grounds for detention.
Protection of habeas corpus is key to limited government, separation of powers, and the rule of law.
Habeas corpus concepts were recognized as early as the Assize of Clarendon in 1166. In response to King Charles II's abuse of power, Parliament passed the Habeas Corpus Act of 1679, which cemented the developed processes for habeas corpus.
In his 18th century treatise on English law, William Blackstone strongly supported habeas corpus to limit the king's executive power, describing the writ of habeas corpus as a second Magna Carta. Habeas corpus has evolved as an effective and consistent tool to ensure limited government.
I'm sorry, I believe one of our unit mates is not in the meeting.
Somebody take over for Emily.
There she is.
Okay.
Sorry, I don't know why my computer kicked me out of the meeting.
Okay, it's your first speaking role.
Okay, sorry about that, everyone. The Constitution recognizes the importance of habeas corpus protection in Article 1, Section 9, by limiting the circumstances in which Congress can suspend the writ to only invasion or revolution. However, this has not always been the case.
Early in the Civil War, President Lincoln suspended habeas corpus to counter efforts to raise hostile troops and sever vital rail lines in Maryland, which greatly threatened the besieged capital of Washington, D.C. However, in Ex parte Merriman, the Supreme Court held that only Congress had such suspension power.
During the Reconstruction period, under the Ku Klux Klan Act's authority, President Grant suspended the writ in South Carolina, detaining over 600 individuals to limit KKK attacks on Black citizens.
After the Japanese attack on Pearl Harbor, the relocation by executive order of over 100,000 Japanese Americans living on the West Coast was upheld in the Supreme Court's decision in Korematsu v. the United States. However, the Supreme Court on the very same day upheld a habeas corpus writ in ex parte endo and unanimously held that Mitsui Endo must be freed unless proven disloyal.
Habeas corpus has also been prominent in our ongoing war against terrorism. Despite previous rulings guaranteeing habeas corpus rights, the Military Commissions Act of 2006 barred prisoners at Guantanamo Bay from using habeas corpus to challenge their confinement. Nevertheless, in 2008, Boumediene v. Bush determined that Guantanamo Bay prisoners retained their right to habeas corpus.
So when, if ever, are habeas corpus suspensions justified in a system of limited government?
The writ of habeas corpus can place an unreasonable burden on the government and its ability to protect the public good. The Civil War suspensions may have saved Washington, D.C. and the Union. During the Reconstruction era, President Grant's suspensions protected a vulnerable population from unlawful violence, and Guantanamo Bay still holds dangerous terrorists.
These suspensions advocated for the common good, what is beneficial for the majority of the population.
In stark contrast, preservation of habeas corpus is essential to limited government by enforcing the rule of law. Judicial deference during World War II led to the shameful detention of large Japanese American populations. The denial of habeas corpus to Guantanamo Bay prisoners would have relieved the United States of justifying those confinements, including those who posed no apparent danger to the United States.
Suspending habeas corpus violates people's natural rights by allowing the government to take away citizens' life, liberty, and property without due process of the law.
We concur with jurist Albert Van Dicey's observation of the British Habeas Corpus Acts, that they declare no principle and define no rights, but they are for practical purposes with 100 constitutional articles guaranteeing individual liberty. Thank you. We are now ready for your questions.
So in your view, how does habeas corpus fit within the guarantee of due process in the 5th and 14th Amendments?
Well, one case in Guantanamo Bay called Hamdi B Rumsfeld in 2004, Yasser Hamdi was an American citizen that moved to Afghanistan and then was found to be working with the Taliban. His due process rights under the 5th Amendment, when he was put on Guantanamo Bay, these rights were restricted, and he filed for a petition of habeas corpus to get these due process rights. So this was one case where habeas corpus and due process under our 5th Amendment worked together because the petition helped people guarantee these due process rights.
Additionally, these due process rights can also be extended to immigrants. For example, in the case Zadivas v. Davis, it was ruled that immigrants could not be held without foreseeable release for more than 6 months. Because of this, we can see that people get due process rights despite possibly not having a habeas corpus writ under normal circumstance.
We can also see in Demore v. Kim in 2003, where Kim was held by INS with no bail due to the fact that he was an immigrant, and this was found unconstitutional.
Okay, when suspension occurs, it's just not the end of the day. What other protections are there in the Constitution that protects people that are accused or from arbitrary conduct by the government? What's the fallback position, assuming habeas is suspended?
The Supremacy Clause in Article 6, Section 2 says that the Constitution is the law of the land and it cannot be gone above. And then we can also look to the 14th Amendment, which guarantees equal protection to all citizens and non-citizens. So it is within the Constitution that these people have the rights to due process and equal protection.
Additionally, we can say even a suspension of habeas corpus is not unlimited. In the case Ex parte Endo, the Supreme Court held that the suspension of habeas corpus could not target disloyal and law-abiding citizens.
Additionally, the 8th Amendment restricts the government from inflicting cruel and unusual punishment upon prisoners, and this relates to habeas corpus as well.
So habeas corpus has been suspended in times of armed conflict, the Civil War, World War II. Are there any circumstances, any times today in modern times when it would be justified by the executive to suspend habeas corpus?
We saw in Trump v. Hawaii in 2018 that under the Immigration and Nationality Act of 1965, the president has the power to suspend habeas corpus or not allow entry to the United States when he believes that a person would be detrimental to the interests of the United States. So this is still a time where we see that the executive can suspend habeas corpus.
Additionally, we can look to the Constitution's Article 1, Section 9, which prohibits the suspension of habeas corpus, or rather allows the suspension of habeas corpus only in times of rebellion or invasion, essentially when the public good requires it. And this precedent holds even today.
We can look to the attack on January 6th. This was an instance where the president could have suspended habeas corpus if he deemed public safety necessary. However, in Article 1, Section 8, as my colleague said, this power is delegated to Congress. So Congress would have had to approve this suspension through either an act like the Ku Klux Klan Act or some other way to transfer this power to our executive branch.
All right, let's go back to the British origins of the Magna Carta, or to the British origins of habeas corpus. That's what we're talking about today. Walk me through how that developed and how that developed alongside other procedural due process rights.
The first example of habeas corpus is in the Assize of Clarendon of 1166, which essentially gave a form of habeas corpus by making it so that when a sheriff arrested someone and brought them to the court, they had to provide a reason for that arrest.
The next place we see habeas corpus mentioned was in the Petition of Right in 1628, where King Charles I was imprisoning people unlawfully in an attempt to get money. So because the principles of the Magna Carta, which was another place we saw habeas corpus mentioned in Article 39 of the Magna Carta, because he wasn't following the principles set in place by the Magna Carta, Parliament forced him to sign the Petition of Right, which in that stated that no person can be imprisoned without just cause. He, however, was found to not be following this petition and was tried by Parliament and beheaded.
Additionally, in the Habeas Corpus Act of 1679, we saw the habeas corpus right really locked down, and it put in place some procedures to make sure that the writ wasn't being evaded, such as jailers can't move prisoners to another prison or out of country to avoid the writ, and if they're found ignoring the writ, they have to pay serious fines to the prisoners. So this is just another place in British history that we see the writ really being locked down in the government.
I'm going to jump back to the previous line of questioning because how do you reconcile the president triggering suspension versus Congress triggering suspension? Because you referenced Trump, that the case of Trump, that with the immigrants, yet you also referenced the Ku Klux Klan Act that Congress ratified after the fact. So give me a reconciliation of how you view who can trigger it and under what procedural aspects.
Well, in Ex parte Merriment, this was a monumental case questioning the constitutionality of Lincoln suspending habeas corpus between Washington, D.C. and Philadelphia. Chief Justice Roger Taney cited Article 1, Section 9, saying only Congress had such suspension power because it is obviously more representative than the president because there are more people in it. So this would stop arbitrary use of executive power. So I believe that that power was clearly delegated to Congress in our Constitution and that the president should not be allowed to suspend habeas corpus.
However,
as well as Aristotle defined tyranny as someone ruling above the law, and with the president ruling above the law and suspending this writ, it'd be found unconstitutional.
However, in contrast to what my other teammates have said, it's important to understand the situation, even though it might have been above the law. As we saw during the Lincoln suspension, the capital of our country was besieged, it was being held, and our entire government was threatened. So the idea that the president took this overstep and possibly saved our government and our capital makes you question the idea that only Congress can suspend it, because we saw it saved our country and our capital, basically.
Okay, we're at time. All right, good job. Yay. Woohoo. All right, it's time for feedback now, so I'm going to turn it back over to the judges.
Thank you for this conversation today. I wish we had more time to continue this. Those 8 minutes always go by too quickly. You guys, I think, did a really nice job. You were able to really effectively and quickly address the origins of the habeas corpus in the question that I gave you. And, you know, right up against that, you're talking literally about things that happened 3 months ago and habeas corpus in the Modern Act. So I thought you guys did a very nice job of being able to look at this philosophically, be able to look at this historically, being able to look at this legally, and frankly, being able to bring this to a very up-to-date set of circumstances. So I really appreciated your conversation today.
Well, I was very impressed with your capabilities to highlight all the tensions. And Stella, at the very end, you recognize, hey, there is a tension. How on the suspension aspect alone, and there's always going to be that. And I think there's flexibility with how it's implemented or suspended. I thought you had a fantastic job on giving us a frame of reference through time, how it's expanded, how it's been used, how it's been exercised, suspended, and what are the purposes and reasons. And Max, I wasn't expecting the 8th Amendment reference. So you caught me there. I appreciate that. I always like to be caught with some things I'm not expecting. So well done. Good team. Thank you.
I would just echo that. Lovely conversation. Thank you so much. Really love the 8th Amendment reference. Actually, I really love the Aziz of Clarendon reference. That was great. And I thought that's, you know, really getting granular as to really tracing the historical roots of habeas corpus and its importance. So nicely done. You guys have an incredible grasp of what is an extremely challenging area of the law, but it was a great conversation. We would have loved to continue it. So thank you very much, really, and kudos to your team and your teacher for, you know, just a great job in preparing you for today. So congratulations, wishing you the best as you go through the competition.